Good morning, everyone. I'm Nina Olson, the Executive Director of the Center for Taxpayer Rights, and we are here today for our third workshop in our series, Reimagining Tax Administration, Social Programs Through the Code. And I am really thrilled to and honored to be the moderator of today's session, which is focusing on design theory and administrative burden. And we have this is a topic that I am really a big follower of, and I have been admiring the work of each of our speakers for several years now. And so I'm thrilled to have them with us today. I'm just going to do a brief introduction and then set up the topic of the workshop today in the context of what we're trying to do with this workshop series. So we have today with us Pam Herd, who is a professor at the McCourt School of Public Policy at Georgetown, and she's a social scientist who focuses on inequality and the intersection of inequality with health, aging, and policy. And her work, along with Don Moynihan, who's also here, on the area of administrative burden as an alternative to policymaking, or as a third branch of policymaking, is really groundbreaking and something that certainly influenced my thinking a lot. Which brings us to Don Moynihan, who is the McCourt Chair at the McCourt School of Public Policy at Georgetown. And his research focuses on improving how government works, the behavioral effects of efforts to improve public sector outcomes through government reform, as well as administrative burdens people encounter in their interactions with government. We have Jim Greiner, who is the Honorable S. William Green Professor of Public Law and the Faculty Director of Access to Justice Lab at Harvard. And the Access to Justice Lab implements randomized field experiments to find out what works for individuals and families who cannot afford to hire lawyers. And so that too deals with burdens, administrative burdens, but not just in the agency side of it, but also with the court side of it, the judicial side of it, litigation. And our last but not least guest is Emily Schmitt, and she is the Deputy Director of the Office of Planning, Research, and Evaluation in the Office of the Administration for Children and Families in U.S. Department of Health and Human Services. And so in that capacity, she oversees the office's research and evaluation work, including the application of behavioral economics to human services. And she's overseen projects related to TANF, employment and training, and homeless and disconnected families. So what all these speakers or panelists have in common is really looking at the interaction between the individual and agencies, whether it's at the state, local, or federal level, and what barriers there are to being able to access benefits, access justice, or various other relationships that the individual may have with government. And that fits into the flow of our trying to think through the process of the IRS delivering social benefits within the tax administration. As you may recall, the first session of our workshops was focusing on how the IRS today processes tax returns. And we did that so that everyone would have a starting point of understanding what the administrative burdens and barriers might be as someone is trying to enter the tax system and obtain benefits that are delivered through the tax system. And so if you haven't watched that after you listen to this session, you may want to go back so that you can look at it in light of what we've talked about here in this session with administrative burden. The second session We talked about the actual characteristics of the taxpayer population that would be trying to access these benefits that are delivered through the tax code. And we learned a lot about the population, including, the changing nature of the families, just some of the barriers that folks in poverty experience. And all of that colors how they're going to interact with the government and how they're able to interact with the government. How can they navigate through the systems? So here we are today actually discussing what is the impact of barriers in government agencies, what is the nature of those barriers, and how might we minimize or mitigate the effect of those barriers. And we're going to learn not just from tax, but from other, government agencies and government interactions. So having said that, I just want to give you a shout out for the next panel as we go along in our little trip, our travel log. And that is, we're going to come back and look at the tax rules dealing with earned income credit and child tax credit eligibility. So our next session will look at, well, are there ways to eliminate burdens or better address the population by changing eliminating burdens even by changing eligibility rules so that they better conform with the characteristics of the population that we're trying to assist. So that's the next step after this one. So I think what we're going to do is we will start with Pam, I think, was the first person that was going to start off the discussion. And here we were going to really take a look at what administrative, explain the concept of administrative burdens. And I think that's Don and Pam. I'm not sure who's going first. And then they'll apply that to, the child tax credit context. So Pam, Don. Thanks, Pam.
So I'm going to start the discussion. Good morning, folks. It's nice to see some familiar faces, including some people we've actually cited in our research, which also includes Nina. So we're very happy to be part of this discussion. So we are both from Georgetown University. We have worked together on this topic for about a decade now. And early in 2019, we published this book about administrative burden. And really, we were motivated by the fact we'd worked in a variety of policy spaces, in academic spaces, but also connected with practitioners, where we saw again and again, people talk about different sorts of frictions that members of the public would encounter in their interactions with the government. And they would a couple of things we observed with these processes. One is that people would observe these frictions and think of them as idiosyncratic to that particular policy domain. And so they might say, well, there's some barriers in the ITC or in voting or in Social Security disability, but not really think about those experiences as connected. The other thing we observed is that people studying in different areas like social work, economics, or public policy domains were not essentially talking to one another about this topic. And so we thought there was value in trying to organize some common language and concepts to facilitate conversations across policy domain and across research areas. And that was to a large degree, the motivation of our book and the concept of administrative burdens. So what we'll talk about today, I'll talk mostly about this question of what are administrative burdens. And then Pam, I think we'll sort of get into more of why we should care about them and how we might think about minimizing them. To help make sense of this, we break down administrative burdens into, first of all, a very simple definition, and then a couple of different types of costs. And the very simple, broad definition is that administrative burdens are individuals' experience of policy implementation as onerous. The thing that's important about the definition is that it puts the focus on the individual and not the state or government. So where the unit of analysis is not government action or particular law, it's people's experience of the state. We also kept it broad by defining individual to recognize the fact sometimes the individuals experiencing the states are themselves public employees, right? They are subject to administrative burdens just as much as members of the public are. And to help make that very broad definition a little bit more concrete, we broke it out into 3 different types of costs: learning, compliance, and psychological costs. So learning costs are engaging in search processes to collect information about public services, to figure out if a public service might be relevant for you, if you're eligible for it, what you might get from it. This is not information that we are born with. It's not innate to us. So it takes some effort on our part to pull that information together. And to give the example of the child tax credit, the expanded version of the child tax credit lowers learning costs for a lot of people, because if you file taxes and are under the income cap, or if you've gotten a COVID stimulus check, then you're essentially automatically enrolled in the program. And so you don't have to invest a lot of time and effort into finding out about it. You might be surprised why there are checks turning up in your account every month, but presumably after a certain point in time, you'll figure that out. One problem though with the child tax credit is that a good number of people are getting it for the first time, or they've become eligible for it because of the expansion, because of the removal of the lack of the earnings offset, which I think we'll probably talk about more. And so in theory, they're eligible for it, but they may not have filed a tax return in the past. The IRS doesn't have their information, and therefore they're not going to be automatically enrolled. And that population, what we know about them is that they tend to have very low income, tend to have some of the disadvantages that we encounter, that we see from people who don't normally get access to benefits. So they may struggle more with administrative burdens. And so there's more of an outreach effort required on the part of the IRS to reach them. And the IRS is not necessarily in the business of outreach to vulnerable social groups. The second type of compliance costs are, the second type of costs are compliance costs. And here it's the cost of following administrative rules and requirements. And this is filling out forms, providing documentation of status, hiring people to represent you, sort of the standard cost of red tape. Again, the CTC scores well on this, at least the expanded version, if you're automatically enrolled. It's a relatively simple program in terms of qualifications, so there's not a lot of documentation that has to be provided. And the IRS already collects information about your status. But again, if you're in that group that hasn't previously gotten it, it's a much higher lift in terms of compliance costs. The IRS put up a website that wasn't terribly useful, wasn't available on people's phones, accessible only in English, that took a lot of criticism. Now Code for America, which is a nonprofit that specializes in digital services, is trying to fix that. But again, there's sort of a different experience for groups that were automatically enrolled versus those that were trying to access this benefit for the first time.
The last category of costs are psychological costs. So these are broad. It's everything from stigma of enrolling. This is in terms of the kind of research on the topic. The most coverage, I think, has come around stigma, right? Like the fear of being associated with poverty-based programs, and the ways in which the designs of some of these programs like exacerbated that. So the classic example being how they used to distribute food stamp benefits, that you'd have to do an actual stamp booklet at the counter. And then they switched over to more of like a credit card version partly to reduce stigma. But there's also a lot of other costs just in terms of stress, loss of autonomy with interactions with the state. For many benefits, the consequences of not being able to get these benefits because of this sort of red tape that you encounter, the burdens you encounter in those processes is actually really stressful for people. And there's some evidence about kind of consequences of that stress for people's kind of psychological health and possibly general health as well. So the CTC in that regard, as Don has sort of already mentioned, generically is positive from the standpoint that it's a benefit, at least for the moment, that everyone gets, right? The whole point is that everyone's eligible for it pretty much, with the exception of very high income populations. Everyone gets it. It's just coming through the tax system. It's not coming through some sort of agency where you're doing a lot of documentation requirements. So all the kind of sometimes negative things that come with programs that are hugely beneficial for low-income populations is not actually really present in the child tax credit, at least as it's currently designed. The program that we look to most positively in this regard is actually Social Security benefits, particularly retirement benefits, in terms of thinking about low levels of stigma and kind of really positive associations. Indeed, there were some proposals to actually distribute the child tax credit through the Social Security Administration, in part because of their administrative expertise in terms of distributing benefits, but I think also because of the positive connotations associated with the Social Security Administration versus, for example, the IRS. Okay, so why should we care? As Don has already made the point, right? Like this is particularly for the child tax credit, the population that we're really worried about here are the people who will most benefit from it, actually, the people, the kind of poorest Americans eligible for it, who prior to the expansion didn't have the earnings record that you would need to qualify for the child tax credit. But these are also people who don't typically file for benefits. So they're not benefiting from the kind of automated nature of the benefit. The big picture in terms of the consequences for this is that initially, I mean, the estimates now basically are 1 in 10 of those eligible for the benefit are in fact getting it. So in that sense, we can think about it as maybe a success. The problem is, though, that the people who most need it, again, are at the bottom end of the income distribution. And in fact, there's a recent study that just came out of Michigan in the past few days that focused on SNAP recipients, basically. They were able to get data on SNAP recipients. And effectively, we're only finding about 2/3 as of August of SNAP recipients were receiving the CTC. There's different reasons about why they weren't able to access it, but some real concerns there basically about that population at the bottom and their ability to access it. In terms of the solutions here, though, I mean, part of the point here is that these kinds of burdens that are built into the system, the sort of details of administration, they can be really problematic because oftentimes they're basically not well understood by the population as a whole. But there are, I think, importantly, ways to fix them, right? They're a product of kind of administrative and political choices. And the consequences, they get designed in there, but they can be sort of designed out again. They can be pulled back out. And this is true for the child tax credit as well. Now, I think there's the politics of this point are complicated, though, because we have there's sort of two tensions right now. On the one hand, there is a lot of attention to figuring out how to reduce these burdens and get access to low-income populations for the benefits. I think what's on the table now are sort of two ways to think about it. One way is effectively on the design side. Are there ways over the next couple of years, if we can keep this benefit in place, that we can alter the design mechanism to decrease burdens? Alternately, we can think about outreach, basically, and really effective third-party outreach. And I think this is where we actually have a lot of opportunities with the child tax credit. There are a lot of agencies already on the ground that try to help people access, for example, the earned income tax credit. And we have the same potential here to reduce burdens with child tax credit by improving outreach via third parties, collaboration between the IRS and these third parties, for example, providing organizations information about sort of generically where they can target their outreach, for example, as well as cross-agency exchange of information potentially between the IRS and the Social Security Administration. The flip side here is, though, and the concern is that the expansion is only temporary. And as of last night, there was some talk basically about, there's been talk for a while about work requirements being added to it. And from a burden perspective, this is troublesome, because the addition of work requirements means the addition of burden. And in some policy areas, we find basically that work requirements, for example, in Medicaid, would do little to increase employment, but the majority of access problems not come from people not working. The majority of access problems with work requirements come from being unable to overcome the administrative hurdles to document that work status. And so there's some real concerns here. If we go the other direction, basically, and we add work requirements to the child tax credit, or sort of add them back in, basically, we're really going to reduce the ability of people to access the benefit. We kind of already know with the earned income tax credit, sometimes people face issues, for example, with employers if they left, or if you're self-employed documenting income. There's just going to add another layer of hurdles basically to this benefit. So we'd kind of be going in the opposite direction. So I will stop there. Thanks.
Thank you. So now I think we're going to go on next to Emily, who's going to talk about some of the experiments and initiatives that her office has been working on.
Hey, thank you so much, Nina. Thanks for inviting me today. I'm Emily Schmitt. I'm from the Office of Planning, Research, and Evaluation in the Administration for Children and Families. And trying to advance my slides. Let's see. There we go. Okay. So just some quick background on ACF. We're part of the Department of Health and Human Services. We are a human services operating division. We're primarily a grant-making organization. So I would contrast us with the IRS in that we're not directly providing a lot of services. We're mostly giving money to states, or we're giving money to other local entities, and those states are turning around and providing programs such as child care subsidies, temporary assistance for needy families, child welfare and foster care, child support enforcement, adolescent pregnancy prevention, and more. So that is, you'll see some of the challenges we have in terms of designing programs and the data that we have on our service recipients. We administer over 60 programs, so we also have quite a lot of programs coming out of ACF. And I'm in the research office, and our job in OPRE, which we call ourselves, is to build and disseminate evidence about effective approaches to helping low-income children and families. We do impact studies, we do descriptive and implementation research, we do research syntheses, and our goal is to try to learn how to improve ACF programs and generally learn how to improve services to the populations that ACF serves. Today, I will be talking to you specifically about some of our work applying behavioral economics, behavioral insights to human services. This is work that we began back in 2010, and this was a time when the idea of behavioral economics, behavioral insights was, I would say, seeping into the popular consciousness through the publication of books like Nudge by Cass Sunstein and Richard Thaler. And we heard about this idea that you could make a small, low-cost change to your program and you could have an outsized impact. And that was very exciting, especially in this time when there was a lot of talk about budget constraints and not wanting to do more expensive programs. And we were thinking, okay, maybe we can tweak our programs and have some outsized improvements. But there was also definitely skepticism in our own office, in our agency, again, federal agency, decentralized, giving money to states and other local entities. How much can a nudge design intervention really make a difference in the lives of the families that our programs are ultimately serving? So we set out to try to learn about this, to try to do some exploration and some testing. This is work we did in partnership with research contractors, primarily MDRC, and I am going to give a shout out to Patrick Landers, who I see on this call, who was part of this project in a prior role. So just kind of some quick background for people who may not be familiar, but basically we were taking this idea that, if you go to public policy school, which I did, you learn in Econ 101 that people are rational, and that if you have a benefit that you're offering them and the benefit exceeds the cost of applying or or complying with the requirements, then you're going to get that benefit. And we were chasing after this idea that actually people are not rational and that humans often act in ways that would deviate from what would be predicted by neoclassical economics, but public policy in a way is not acknowledging this in the way that we design our programs. And could we leverage insights from this body of work to try to improve the way that our programs interact with service recipients? So at a very high level, we're trying to say, can the way that we interact with clients take into account that people, maybe particularly low-income people, but everyone, can only pay attention to and understand a limited amount of information at a given time, often give more weight to the present than the future, can be really influenced in an outsized way by small factors, are influenced by how they see themselves and others, and can be more motivated by losses than by gains. So we set out to see, can we take some of what we know about how humans actually behave and make a difference in some of our programs. And we started by really trying to solve some immediate program issues. So start small, can we make iterative improvements to short-term program goals? And mostly we were doing this by changing the way that programs communicated with clients. So I'll give you a flyby overview of the different types of problems we were trying to solve. So in California, we were trying to get TANF recipients to show up to a meeting that they were actually required to show up to keep their benefits. In New York, we were trying to get people to show up to an informational meeting about a benefit that they were eligible for. In 2 counties in Ohio, we were working on trying to improve child support collections. And in Texas and Washington State, we were working on trying to get people who were potentially eligible for a lower child support order to apply for a modification to that order. In Oklahoma and Indiana, we worked on trying to help parents recertify their child care subsidies on time so that they didn't have a gap in subsidy receipt, which turns out hurt the parents, but also helped hurt the child care providers if there was a gap in subsidy receipt. And then in Indiana, we also worked on trying to provide some personalized assistance to help parents use their child care subsidies for higher quality providers. And although we were working from this general idea that people are not as rational as public policy designers might think, we were very particular in each place where we worked. So really trying to zoom in on the individual problem, what exactly is going on with this agency, what's the process they're hoping someone might go through, but what are all the steps that someone might need to take? Are there particular places where we can either see in the data or where we can know that people are dropping off? And are there potential design interventions that can happen at any of those particular places in the process? And then we were, in each case, designing an intervention and testing. I'm just going to go through 2 examples to show you some of the things that we tried. So as I mentioned before, in California, LA County was trying to get TANF recipients to show up to a meeting, which was required for keeping their benefits, but only about 50% of parents were showing up based on the outreach that the state was doing. And the state was sending, I think, a 17-page letter to parents. And so we couldn't change that letter, but we tried to send an additional letter with some tweaks that we thought would improve attention and action. So for example, simplifying the message, putting on the first page in bold and underlining, what is this letter about? What are you being asked to do? Adding in some planning prompts, so asking people to think in advance and write down how would they get to the meeting, what would they do with their children during the meeting. Personalizing the letter, so including a sticky note that was from, or looked like it was from their caseworker, trying to create a sense of reciprocity that we hoped would nudge people to show up, thinking that someone in particular was waiting for them. And then we experimented with some letters which emphasized what someone would lose out on by not attending the meeting, and then some that emphasized what people would gain by showing up. And the sticky notes also had this loss versus gain frame. And so what we found was that receiving any sort of behavioral notice increased re-engagement by about 3.5 percentage points when we checked in 30 days later, mostly driven by the loss framed letter. Next example, which is actually not of an ACF program, but is a little bit tax related, is that we worked with the Paycheck Plus pilot in New York City, which was a pilot that was testing an EITC-like payment for adults without dependent children, testing a more generous payment that was closer to what someone with a dependent child would get from the EITC. And the way this program worked was that you were recruited to be part of the demonstration in the fall of 2013. You needed to work on the books in 2014. And then in the spring of 2015, you could get the bonus if you remembered that you had to report actually outside of the regular tax system because this was a demonstration project. And so the demonstration was offering an informational meeting in the spring of 2014 to remind people you signed up for this program, you need to be doing something this year in order to get money next year, which of course, you can already see how this is a big psychological leap for someone to have signed up for something in 2013 for a benefit that we're going to get 2 years later. But our goal was to try to get people to show up to this informational meeting. And we did that by trying to improve the design of the communications that people were receiving. So these were the kind of standard postcards that they would be getting telling them about this meeting. And there was also an offer of $50 for showing up. But our team redesigned the postcards and did things like turning what you needed to do into a process and checking off the first step to make people feel like they were already making progress on this process. Putting in some planning prompts, asking people to check off the date and the time that they were going to go to this meeting. Making the deadline more prominent and also making it artificially early to leave people time to be late but still be eligible. Using that same loss aversion frame, so the postcard says $50 is yours, don't miss out by not coming to this meeting. Giving people fewer choices, so the original postcards had a bunch of different locations you could go to, and this one has one location that was close to the address the postcard was being sent to, and one that was centrally located in the New York borough. And then we randomized, so some people got the behavioral postcards, some people got the regular postcards, and then these groups also were randomized to either receive text messages or not with information that matched what was on the postcards. And again, we found that receiving any type of behavioral messaging led to a 7 percentage point increase in meeting attendance, and that there was a 12 percentage point difference between the group getting sort of the least design-informed outreach versus the most. But you can still see a lot of people are still not going to the meeting. So they did a round 2 as well. And this time we're trying to remove the burden of having to go in person by offering a phone meeting. So of people who didn't come in the first round, people were re-randomized to either have another chance to go to the meeting in person or be able to call in. And this time everybody got bombarded with phone calls, text messages, and postcards. And you can see what you're seeing here is that the phone group participated earlier, although at the end of the day, the in-person group caught up and there wasn't a difference in ultimate participation at the end of the day. So we did tests like this 15 times in 7 different states, again, kind of focusing on these pretty short-term program problems. Is someone going to show up to this meeting? Is someone going to recertify their benefits for the next eligibility period? Is someone going to pay their child support this month? Overall, we found pretty consistent, modest, positive effects. So all the sites that we worked in saw a significant impact on at least one of the outcomes they were working on. Most of them were 2 to 4 percentage points, although we did have some larger outliers, which, as time goes on, we feel like is pretty typical of this type of intervention in this field. These were pretty low cost, so typically less than $4 per program group member. And again, typically modest impacts, but we found them to be promising because they were consistently achieved, low cost, scalable. And as I said, we administer 60 programs. So we're thinking if someone is participating, if a household is participating in multiple programs and each of them is a little bit easier to access, that's meaningful. Of course, also not a silver bullet. So we were making changes on the margins, trying to make these programs a little bit easier to participate in, comply with, get benefits from, but certainly not, but consistent, modest effects. So we are building on this work right now. So we're trying to do a few things with our next round. One is just expand the reach of the ACF programs that we're working with, but we're also trying to see, okay, seeing that changing the communication can have this consistent and modest impact. Can we go a little deeper? Can we apply these principles to the processes that people go through or the way that caseworkers interact with them? It's been challenging. It's easier to convince a program to test the letter them they're sending out than it is to convince them to change the way that they fundamentally interact with clients. But we're working on it, and we don't have any findings from this round yet. And then I always also have to put in a plug as well that we have a dissertation grant program. So if you know of anybody who's a graduate student who's interested in human services and behavioral science, we typically give out grants annually for that work. And I will just leave you with where you can learn more, which is on our website. We have a newsletter, we're on Twitter, and I will leave it there for now. Thank you.
Great, thank you, Emily. Just a reminder, you can put your comments and questions in the chat if you'd like. And now we'll turn to Jim to talk about the work of the Poverty Action Lab. Jim?
Actually, the Access to Justice Lab, the Poverty Action Lab, is an excellent institution. Just doesn't have to, over at MIT, right across the road from us, just doesn't have to be the one that I'm associated with. I'm just going to share the screen here. So I think what I'm hoping to contribute to the discussion today is an appreciation for two different responses to the problem of administrative burden and the take-up of benefits, recognizing the fact that that both involve a certain amount of lawyer or legalese or legal writing or legal analysis or legal something, because they are all about legal principles as applied to a particular set of facts and whether an individual is eligible for them, for benefits or for some kind of burden reduction. And every time you involve legalese or lawyer, you get administrative burden, which is the theme of this morning's presentation. One of the themes is outreach, which Emily has largely stolen my thunder on in an excellent way, in the sense that we have also at the Access to Justice Lab been attempting to do some experiments, some randomized experiments to figure out what works to get people to show up to court that could be applied very directly to get people to show up or to proceedings that they have to show up for to remain eligible for benefits or for some sort of burden reduction, tax burden reduction, for example. And we have found largely our results consistent with those that Emily demonstrated in hers. In her presentation, which is that they generally work. The outreach, especially as Emily has demonstrated, outreach that is behaviorally informed appears to work generally. It appears to be low cost, it appears to be scalable, but it's very far from a silver bullet. So our initial approach, which we implemented in an attempt to try to induce individual suit and debt collection proceedings, particularly credit card debt collection proceedings, was to try cartoons, because we decided that we would try to go to literatures from industries and sets of scholars that had encountered similar challenges to those that we thought we were encountering. And given the fact that in debt collection proceedings, upwards of 90 to 95% of individuals typically don't show up to contest them. And again, this is consistent with some administrative processes involving the attempt to obtain a benefit or again, some sort of burden reduction where show up rates, as Emily mentioned, were fairly low. And so what we did was we went to the adult education literature. We tried to find publications from junk mail providers. I don't know if you call a junk mail industry member a provider of something, but anyway, we went to their literature. And especially from the adult education literature, what we found was a heavy emphasis on images as a way to try to grab people's attention and keep it and to communicate messages. Images, however, turned out to be a chore, a real challenge to design well. As lawyers, our instinct was to try to put as much information into images and as much information into text as possible. We're lawyers, we enjoy complexity, we enjoy challenges and puzzles, and we pay attention heavily to text. And that's not how normal people think. And so we had to think like non-lawyers in trying to design these interventions. And in particular, we had the assistance of a law student who later went off and founded this nonprofit organization called the Graphic Advocacy Lab, that uses graphics in an effort to try to further the availability of the legal system for individuals who can't afford to hire lawyers. So this is an example of some of the things that we came up with. We came up with a suite of cartoon characters. We call this this person Fat Cat. This is the debt collector or the debt collector's lawyer. Blob is our sort of every person. Blob is genderless and raceless. So we've removed clothes from Blob. We've removed hair from Blob in order to suppress race cues, gender cues, class, socioeconomic class cues, et cetera. And then we have a lawyer here that we've attempted to try to make friendly and inviting in order to get people to, say, take up legal assistance. And we put these in letters that we sent to individuals who were sued in credit card debt collection proceedings, and we roughly tripled the rate at which they showed up to contest debt collection proceedings, which sounds fantastic when you consider that we tripled it. However, we tripled it from about 4.5% to about 12%. So it helped, and it was definitely statistically significant. All of our statistical tests when we randomized the sending of this letter versus not the sending of this letter, just went wild. This is highly statistically significant. This is fantastic. What it left us with was still around 85% of people not showing up. So again, the message appears to be here the same as Emily's, which is it is scalable, it is cheap, it helps. But you've still got work to do and we still don't appear to have figured out, at least I have not seen in the literature that I try to follow, what sorts of outreach work that in criminal justice context. Various folks have tried text messaging. When you have a phone number, people who are arrested sign up to provide their cell phone numbers. And the text messaging of reminders of when court dates are coming up. And again, the results there are kind of the same. Text message, very cheap, buys you some percentage points, sort of in the 4 to 8 percentage point range of failure to appear reduction, but doesn't completely solve the problem. So there's still plenty of work to do, although I think these measures are worth implementing because, again, they are cheap and scalable. And there appears to be a large variety of options for folks in various government agencies to choose from or to experiment with, which is probably the best way to go, because I think, again, I'm echoing Emily's message here that the best way to do this is to contact your local nerd, get in touch with the nerd and get the nerd involved in some sort of randomized experiment, which is the same methodology that we use to try to figure out whether COVID-19 vaccines work or cancer drugs work, or that allowed us to figure out that penicillin works, and run a randomization where you send some outreach of certain type to some you may not send outreach to, others you do, and figure out what works best and then go with that. So that's in the general category of outreach. Another way that folks have proposed to reduce administrative burden, especially with these tax burden reducing or benefits programs, that involve a lot of legalese and involve a lot of lawyers, is to provide people with lawyers. And I guess what I want to say about that is, number one, there's a fair amount of research, including excellent research from a MacArthur Genius Award winner named Becky Sandifer, that suggests that people are frequently highly reluctant to do that, to contact and get in touch with a lawyer. There's also a bunch of research into whether getting people to lawyers, or at least offering people lawyers when they get there, actually helps them. And that research turns out to be quite mixed. So for example, in this paper, the offer of an attorney-client, traditional attorney-client relationship in a housing court setting, which is supposed to be a relatively specialized setting designed to reduce the formality of the proceeding and make it more pro se accessible. The lawyer versus a lower form of legal assistance, and likely no lawyer assistance at all. All of those, none of that made any difference in terms of the outcomes that the tenants were experiencing. In this paper, the offer of legal assistance from a law school clinic likely inflicted a mild harm upon the clients. And in one of the two studies in this book, the lawyer assistance made no difference whatsoever. In the other of the two studies in this book, the lawyer assistance made a large difference. And in this paper, the lawyer assistance made an absolutely enormous difference in the experience that the would-be clients achieved in terms of achieving their legal ends. What it suggests is that unfortunately we don't have, again, we don't quite have a silver bullet here in terms of whether legal assistance in terms of form of traditional attorney-client relationship, or getting people to legally trained help to the extent that the bar will allow that under the unauthorized practice of law rules, which is something that the bar in its sort of cartel type behavior has been very reluctant to allow in certain settings. Whether it actually does people any good. And so I think that's also something that needs to be studied. As part of that theme, given that some people are highly resistant to going to legal assistance at all, they'd rather go elsewhere to try to solve problems that they're having. Given that we don't know whether legal assistance is going to help them, and given that legal assistance, even non-lawyer legal assistance, is extremely expensive, it turns out to be difficult to scale and difficult to provide at large quantities and difficult to arrange. It's likely that self-help is going to have to be part of the picture. And so one of the things that we've been attempting to try to do in the Access to Justice Lab is to see if we can find ways to reduce the administrative burden of implementing self-help. In other words, filling out the forms yourself, getting through the process yourself, diagnosing whatever legal challenges, and they typically are legal at this stage, that you might have, reducing or solving barriers that you might encounter to obtaining, the benefit, the government benefit, or the tax burden reduction, or whatever it is. And again, we consulted the same literatures that I mentioned earlier in order to try to explore whether self-help works in these settings. And this is, I guess I should start here. This is an example of an effort to try to help individuals who are in severe financial distress to the point where they had been sued in credit card debt collection proceedings, either defend the debt collection lawsuit, then diagnose themselves about whether they needed to go through bankruptcy. Why did bankruptcy or debt, or if not bankruptcy, then debt negotiation? Why did that leave us to a tax system? To the tax system? Well, because it turns out, as likely as everybody here in this audience knows, that if you achieve some sort of debt reduction, either via the bankruptcy system or through negotiation, even if you believe, if you know that the debt that you have been quote unquote relieved from was never owed and could not legally be collected. Nevertheless, that might generate a tax form because under standard tax concepts, if you obtain a loan of some kind or some form of credit, that event is not typically taxable as income, but then because under the theory that you have to pay it back. But then if you obtain relief from that debt obligation, that would be, if it was a proper legal obligation, that would be a taxable event because now you no longer have to pay it back. And so folks, creditors often send forms, 1099 forms to the IRS, saying, I just negotiated and I'm not going to try to collect on a debt anymore. And that can generate tax complications. And so we tried to create a self-help form that would deal with those tax complications, and in doing so, tried to create generalizable knowledge that could apply across different tax settings, and you can see that we used our same suite of cartoon characters that we had developed through the help of the Graphics Advocacy Project. Again, actually, that wasn't the Graphics Advocacy Project. The founder of the Graphics Advocacy Project, a woman named Hallie J. Pope. And we used a whole lot of other design concepts. So we researched and looked at the font type that we should use. We talked about how much prose there should be on a page. We tried to reproduce images of the form that we were hoping that people would use, or would have people had encountered. We actually, for the most part, didn't use actual reproductions of the form if we thought they would be too complicated. We used hand-drawn form reproductions, which I'll try to find and show you a sample of, because that allows us to suppress this fair amount of complication. We excerpted forms in order to show only the relevant pieces so people could match. Later on, you'll see we'd reach certain decision points, which is always a problem because the law requires you to branch a lot in your reasoning. The law says, if this is true, then you have to go here and do this. If this other thing is true, you have to go here and do this. Doing that on paper-based forms is a nightmare because it requires you to get people to skip to different pages. And so we had to design different ways to try to do this and get people to skip to different pages. And we put a lot of work into this, including not just by sitting around in our conference rooms and our offices and meetings with students, but in going and talking to people as we could find them, and interviewing folks who were in the situations similar to those that we hoped would use, of those who would use our forms, and getting their feedback. And of course, what we primarily find out was this sheet or this piece of paper or this cartoon or whatever it is has too much information. Simplify it, reduce the amount of complexity, reduce the amount of abstraction, try to make it more step by step. And we did, again, we tried to do that, and we tried to allow people to keep track of where they were with images as opposed to with page numbers, as you can see up here. We don't know whether any of this works yet in the form of self-help. We have one very large, for us, multi-year randomized study that is out in the field now in Connecticut that is closed randomization. And we are in part of a 3 to 5 year follow-up period to see if this overall approach has any benefit. Probably the most obvious challenge to this kind of paper-based approach, which we deliberately chose, we chose paper because we thought a fair amount of our service population would have internet access challenges. Is as you can see up here, because the law is so complicated, the self-help materials have to be extremely long. And that's quite depressing because we're aware of all the behavioral literature that Emily cited, that when people, you get a 91-page document, you're thinking, oh man, I'm never going to make it through this, even if it has cartoons in it, even if reading each individual page is very simple. And so we try to say to people, you're not going to have to go through every page. You're only going to have to go through parts of it. Because again, we're having all this branching in here, and you're probably only going to have to go through 15 pages of it. The problem is the law is so complicated that we have to give you 90 pages in order to get you the right 15, et cetera. And again, we have these images to try to get people to show them what they need to do, and also to keep them encouraged as they go through. However, we recognize that a 91-page document is, again, extremely challenging for people to use. It's extremely challenging even for people to encounter. And again, we don't have a silver bullet response to that. We don't have an absolute response. I will note that as we had thought from the beginning, technology could be an answer to part of this for people who are able to access the technology. And so this goes back to larger social problems about access to the internet and access to different forms of communication. So for instance, the text messaging idea is only good for people who have smartphones, or at least have the ability to receive text and send text. A former student who worked on this project, keep in mind this character right here, founded this group. There's Blob appearing here on this website. This website is upsolve.org, which is designed to help people get through the bankruptcy process. And it has won all sorts of awards and funding from various folks. Where is their list? And been written up in various locations. And it attempts to make a lot of this extremely straightforward and simple through, online guided interviews, which I'm, again, assuming that many of the participants in this sort of setting have seen. And there's Blob again. basically what you do is you just start clicking. And you just start answering questions. And there is software that takes your answer and allows you to branch, and it suppresses the need to even receive something that's 91 pages to handle a simple tax form like a 1099-C, or I should say comparatively simple, like a 1099-C. And then the one key point about this website, though, is that it is not entirely a self-help model. There's a lawyer sitting in the back of this service. In other words, what this service is, upsolve.org, is it's really a question and answer designed to reduce the administrative burden of interacting with a lawyer and the lawyer's administrative burden in obtaining the information the lawyer needs to operate well, so that the lawyer can just turn themselves into a mill and just churn out bankruptcy materials that are all entirely compliant with law and entirely compliant with ethics requirements. It's just a much more efficient way of obtaining information from someone and then allowing the lawyer to provide very sharp legal assistance. One thing we know that this has, as Upsolve has been tracking, where's the little number? We know that they are getting through a lot of people through bankruptcy, and this is the face amount of the debt that they have been able to reduce, and they're very data driven over there, which is why I highlight them. So what we don't really know, though, is this solving a problem that people wouldn't be able to solve elsewhere? We think it probably, our guess is it probably is, because it is, again, it is attempt to address where is it? It's attempt to address this issue right here, the 91 pages and the interface for people who can access it. So what's the overall message? I guess the overall message is, number one, outreach generally does provide some help. It's not a silver bullet, but it is highly scalable, and there are lots of options, and there are lots of nerds, lots of graduate students who are out there willing to engage with you and experiment and try to figure out what's right for your organization, because they can learn a lot of excellent methodology and gain a lot of excellent experience by working with you, field experience. And it generally does appear to provide some results, some good results, and that's gold standard methodology with randomized field experiment. Second overall message is that legal assistance is almost certainly extremely helpful for certain people, but we don't yet really know which people. And so getting people to legal assistance may not be a silver bullet either. It probably also is something that requires rigorous study. And so you're going to need to try to figure out, again, maybe contact your local nerd, figure out not just whether people on average are benefiting from legal assistance, but maybe can you design experiments or different trial and error type things that would say, well, which people are most benefiting from legal assistance? And number three, don't fall into the trap that most lawyers and judges fall into, which is, oh, I set up a clinic, or I set up some self-help, legal self-help, and I legally train some people, and so I have solved the problem. In fact, it's extremely expensive in terms of information and search costs, in terms of finding, getting to legal assistance. Frequently, you have to fight through in an intake program, an enrollment program, and determine eligibility for legal assistance providers. Very few people can do that. Very few people want to do that. And it may be that the people who can do that are the most motivated, the ones that have the strongest social networks, the ones that would solve the problem on their own. We just don't know. In which case, for everyone else, it might be that self-help has to be part of the picture in order to reduce administrative burden, and then try to think hard about, well, how can I try? What kind of population am I dealing with? Are they likely to have internet access? If so, is there some way I can take advantage of that? For those who aren't, what kind of self-help can I try to provide to them to reduce their administrative burden and the challenges that they have in producing and getting through the program that's been set up? So those are my messages. Thanks very much.
Jim, really thanks for that very thought-provoking presentation and the information that you shared. I'm talking about cancellation of debt in 2008 with the mortgage crisis. when I was the National Taxpayer Advocate, we were trying to work through and develop some materials to walk people through the consequences of foreclosure, the tax consequences of foreclosure, cancellation of debt. And Congress had passed some legislation to give some exclusions for, qualified residents, mortgage interest, et cetera. And there was no publication dealing with cancellation of debt. It was spread out between 3 IRS publications. I think I added up 474 pages where there was no blob and dense text, very few diagrams, tons of worksheets. And so we worked with the IRS Publications Office to create a publication just on, foreclosures and other cancellation of debt, student loan, credit card loan, cancellation of debt. But in the process of that, in the law, there was an exclusion for insolvency. And this was certainly the category that I thought was very important for what was happening to people in the financial crisis of 2007 to 2010, that these would be people who would be eligible for insolvency. And so we were trying to create a worksheet, a process, just really an easy, how to calculate insolvency, self-help, how could you do this? And then that would come to the basis of someone maybe they could fill it out and send it into the IRS when they got one of these automated notices that said, we've got a 1099-C, you didn't report this income. You could just fill out the worksheet, send it in, and the IRS would know what to do with it. And we went to the Forms and Pubs people and they said, oh no, it's too complicated to figure out a worksheet. And I thought, well, if the IRS can't figure out for their own people, we went to the exam folks and they said, no, it was too complicated for the auditors to have a worksheet either. So we actually sat down with some folks from a federal advisory committee that we oversaw, the taxpayer advocacy panel, and there were some CPAs on, and we really worked out a worksheet, which then we gave to the auditors and we gave to the IRS so that but we tried to put it on I don't know whether it's still up on the Taxpayer Advocate Service website. But that was a really fascinating exercise where the agency itself was like, this is just too complicated. We can't do this. Even when they were going to face taxpayers who were going to, that would have benefited from such a thing. And I think that goes back to Pam's and Don's work, which is that sometimes the agency processes themselves, are bringing about a burden and a result, it results in, if people can't show insolvency, then they've got a tax debt that they aren't legally entitled to pay because it's not accurate, but they can't prove it. And the agency itself can't be bothered to explain it in an easy way so people can avail themselves. I did have a question. That was a comment. And then I did have a question. I know others are writing as well. About, you've been focusing, Jim, on the court level and access to legal services, but I was thinking about, legal assistance at the administrative level, and that's really relevant to the child tax credit. As easy as it may be to get into the system through either a non-filer portal or just already filing a return, as we saw in our first session, is any number of ways for the return itself to get stopped along the way. And so someone has to have self-help to be able to, dislodge it so that you can get these benefits, or you may need legal assistance or some kind of assistance, whether it's navigator assistance, but somebody to help you deal with the agency at the administrative level. And I was wondering whether you had done any work at the administrative level.
So this paper here was actually with legal assistance in an administrative proceeding, specifically an unemployment process. And it suggested that the offer of representation from a student clinic inflicted a mild harm on the client or the would-be client. And so what we did in that particular setting was to try to figure out, well, what's going on there? How can that possibly be? Because we all, as a law professor and law students, we thought that more lawyer is always better than less lawyer, and some lawyer is better than no lawyer. But that just has to be the way the world works. In this particular case, however, there have been a lot of things that the agency involved, an unemployment agency, had done in order to render its administrative decision-making process more accessible. One of the things it had done is it had taken on the burden of obtaining relevant documents itself. And the second, when you file for an unemployment, at least in Massachusetts, when a person files for unemployment benefits, an official called a claims adjuster contacts the former employer, and if there's a dispute going on, and demands the employment file. And basically, in essence, just self-conducts discovery. The adjudicatory agency self-conducts what lawyers would call discovery. And then when there is a hearing, when we go to a live hearing, for example, this is another example, the decision maker, called a review examiner, asks questions. There is an opportunity to cross-examine, there is an opportunity to ask questions of your quote-unquote client and all that, but the review examiner asks the questions. In other words, this is an inquisitorial, what lawyers call an inquisitorial style of adjudication, as opposed to a purely adversarial model. And so that can help. That may be one way of helping, particularly the obtaining of relevant documents, because paperwork, lots and lots of behavioralism research has suggested that paperwork burdens are a real difficult thing for folks to use. Excuse me, for folks to get through on their own. The other thing, though, was that we had some questions, and this goes back to what I suggested earlier. We had some questions about the particular law school clinics' enrollment and intake and outreach models, in that they didn't do a whole lot of outreach. They depended upon phone calls to their offices to decide to whom they would offer representation. And that may have culled the client base, in the sense that you got mostly extremely motivated folks who were able to contact folks with strong social networks, folks with the ability to manipulate, say, software, to do Google searches and that kind of thing, to find legal assistance. In other words, folks that might be able to solve the problem on their own without the legal assistance. That can't be true, and it isn't true of all adjudicatory systems, including those in administrative agencies. And in particular, we found, in other court systems that involve things like long waiting periods, paperwork that it uses abstruse terms. In one of the papers that I showed to you earlier, there was an individual seeking a divorce had to file something called a precipe to transmit the record to the prothonotary. And I've been doing law for 25, 30 years. I still have no idea what that means. I mean, I now know what the document is and what its function is, but I have no idea what the title of the document means. And those are obviously some things where you'd expect some legal assistance, in an administrative context. So IRS forms are typically written by, identified by complicated numbers, right? Usually with letters that go after them. And nobody knows what those are if you don't have a fair amount of training. So I'd expect that kind of thing to provide some guidance. The other thing that I think you mentioned, Nina, is that it may not be just the level of complication of the forms. It could also be, again, things like waiting periods and status checks, because that's something that many people have a lot of trouble with. Again, the theme of today's presentation about administrative burden, many people have a lot of trouble with checking, writing down your calendar 2 months later, check the status of this thing, call this number, fight through the process again to try to figure out where your application is, or whether it's gotten stuck somewhere, whether it's gotten denied in some way and you didn't get notice of it or something like that. And so again, that part in particular is something that you don't need a lawyer for that at all. You may need some software, right? You may need some reminder software. And so it's not just outreach that could potentially be a place for, blob or behaviorally informed messaging or something like that. It may just be status reminders. Hey, call this number and check whether your EITC application has, whether it's been granted or something like that.
So I want to give Emily and Pam and Don a chance to weigh in on, on one another's presentations. There's some thoughts that have been triggered by some of the things that we're doing. And then I have some thoughts about CTC that I'd like to throw out to you. But Pam, Don, Emily?
Yeah, I mean, just sort of stepping back, I think one big picture thing to think about in terms of solutions is like, what is our goal? Is our goal to increase take up of something like the CTC by 5 percentage points? Or is our goal to make sure that everyone who is eligible for this benefit will get it? And the intervention looks really different depending on what that goal is. So for a program like Social Security retirement benefits, right? Everyone who's eligible gets it. And it's not an uncomplicated program. The Social Security benefit, I mean, keeping track of people's earnings over their entire lives, right? Like that's not a simple thing to do, but we designed an administrative system to do it accurately, to do it in such a way that there isn't fraud, and to do it in such a way so that everyone who is eligible gets it. I think some of what we're hearing from both Jim and Emily is sort of nudges in this domain can help, but probably are not going to get us to everyone who's eligible gets it. And in terms of the, how do we get to everyone who is eligible gets it? I think it just simply, it either requires policy simplification, like you make the policy simpler, or it requires more work on the state side to shift more of that burden over to the state. So better collaboration between the IRS and Social Security Administration. You know, Social Security Administration, you dig through those data, right? You can find out who is eligible for this benefit and not getting it. Now, of course, I understand all the, I mean, I actually don't understand all the legal complications of doing it, but that would be an administrative solution. If we can't do that though, if the administrative complexity is just too overwhelming on the legal side about that kind of data sharing, then you have to do intensive outreach, right? Like really intensive outreach where you're not just providing information to help people do it themselves, but you're probably doing it for people. And that's the sort of on the ground third parties. But it really just depends on what's your goal. So I'm going to argue that the goal should be 100% take up. And that requires a certain set of things, but it really depends on your goal, I think.
Yeah, I'd add to that. The type of intervention partly depends on where you are in the policy process, and partly depends on the nature of the problem. And so informational nudges work really well when a key problem is learning costs. Like people just don't have the right information in front of them at the right time. And if you can target them with that information, it can make a really meaningful difference. There are some cases, you know, to use an example in education where the FAFSA form, we've got a lot of evidence that telling people about FAFSA doesn't really increase things like take up because people are already aware of it. The challenge they have with the form is that it's incredibly complicated. And what they need then is help. So help gets them forward. Someone who will walk them through the process, someone who will help them fill out the forms, or help by the state making the process simpler. So partly, you know, if you're thinking about a broad toolbox where informational nudges are part of the toolbox, I think sort of Emily hinted at this, that, you know, they're attractive because they don't require you to change any laws. They're cheap to implement. But then if you start asking agencies to change their processes, then you tend to get a little bit more resistance, even though there might be cases where you need more of that. With the CTC right now, we're at this process where we're really early in the stage of policy design. Like we're making a decision right now about what the future is going to look like and whether it'll continue on the sort of expanded, simplified course, or whether it'll undertake more work requirements. And I think, you know, just part of having these discussions means acknowledging if you start to add more work requirements, that's going to mean that the program is just going to be more complicated. And there's going to be, you know, whatever you can do in the long run to fix that is just going to be constrained by these initial choices that you make today.
Yeah, you know, as I think about the CTC, where we are in the process, you know, Code for America's app has has minimized some of that getting into the process. And there's certainly a huge outreach effort to get people to sign up. And so again, going back to our first session, then you get people in, and what happens to them, what once they're in, some of the data showing people who tried to use various apps to get in and they still haven't received their payments. Why is that? And then what's their reaction to that? And I don't know whether that fits in under stigma or psychological cost, that it's scary to have to apply to the IRS. And it's even more scary if something doesn't happen that you're expecting to happen with the IRS. There's always that fear that they could do something terrible to you. And then moving from there, would you ever try it again? Would you come back in the filing season and apply for the second half of something or the full credit, which you didn't get paid during the year because your return got stopped by something? So we've been at the center, what we've been trying to do is think about levels of assistance based on where you might get chewed up in the process. And part of what we're trying to do, certainly for this coming filing season, working with many different partners, but getting information out there. And I think Jim's and Emily's work has been really helpful in trying to think about the framing of that information for taxpayers themselves, where they could expect problems. And then this is a branching what to do. Here's what you can do yourself. Here's what others can assist you. They don't need to be lawyers. Here's where you may need someone, whether it's because of the legal complexity of what you have to prove, whether it's because of the abstract terms that are there, but you need someone to navigate the process that has some kind of legal training. And so you're splitting off and trying to Jim's point about getting the right people, the right kind of assistance that they need. And education. That's sort of what we're struggling with right now for the coming filing season. And, just we'll see what happens. Emily, do you want to add any thoughts on this topic?
Yeah, sure, just a few. So, I think both Jim and I were saying, world as it is, people need some help. This is like some scalable help we can give. And then I think there's sort of three other levels of intervention that we've heard people talking about. One is personal assistance. So, beyond the letter, can you help, or can personal assistance help people navigate complex systems? Hopefully yes, but hard to scale. Then I think where we're at in our next round of what we call bias next generation is, okay, can we get programs to change their processes? And it's really hard. People don't, the bandwidth is not there, the capacity is not there. There are legal barriers. So I think there's a lot of promise, but it's not like you can just flip a switch and say, okay, like this letter campaign worked really well, so now let's change the way that you flow people through your program. And then the fourth level is policy. So, automatic enrollment and, making better defaults. But, that's the ideal world.
I just add to Emily's comment there. I wanted to pick up on a comment in the chat actually for Melanie about changes within the organizational culture of agencies. And partly we've been talking about these changes as something that can be added to programs. But a huge part of the challenge here is, I think, having organizational cultures that are willing to experiment with different approaches, that are open to adjusting their processes, that start with questions about administrative burdens and examine those on a regular basis. And that brings us to a different sort of set of questions, like how do you institutionalize those values? And obviously Nina has sort of a wealth of experience from that perspective in thinking about the IRS, but how do you embed a value where people are thinking about the experience of the public and then thinking about how do we learn about our internal processes and how those are experienced by members of the public? How do we cultivate an ethic of experimentation and continuous learning and improvement? That means that we're not waiting for someone from Georgetown or Harvard to come and help us, but that it's almost built into the organizational culture.
And I think, I mean, part of the challenge of that is that policymakers don't take the administration very seriously, right? So I love the way that Emily laid out like these different levels. And even in providing the right support for the IRS to administer the CTC, for example, or if you look at what's gone on at the Social Security Administration over the past 15 years, like their administrative budget has just been gutted. So I think partly it's about getting policymakers to understand that also you have to support these agencies to actually do this work. I do think the one kind of inherent challenge for the CTC around the IRS is the sort of effectively now this agency with a dual mission, right? Like it has this collective sort of penalizing almost, or can be perceived at least as a penalizing mission, but now also this mission to deliver a large amount of social welfare benefits. And so I think it can be confusing for people on the psychological side interacting with an agency that has these dual missions. We have a colleague at Georgetown, Dave Manoli, who's done a bit of work on how, I think it's Dave's work, about the implications of once your EITC has been audited, basically. That like people sometimes won't go back basically once they've been audited and are afraid to apply again basically for the EITC. So that's a good example where that dual mission just gets really complicated and makes the program harder to access as a result.
Day gave a presentation at the 6th International Conference on Taxpayer Rights, and we'll be posting a video of his presentation just on that. It was really looking at digitalization of tax administration and how it can help and how it can hurt. It was really interesting. I want to give Melanie a chance to talk. I did want to, I can't pass up the thing about the dual mission. When I was in Australia, early, maybe 2010, 2012, and attending a conference, and the Commissioner of New Zealand's Inland Revenue, they had just received the responsibility for administering not just a child and family benefit, but also collecting child support. And he gave a talk about having to realize that his agency had suddenly become a benefits agency, in addition to being in addition to being inland revenue, intake of revenue, and what that meant and what they were trying to do. And they really did set up a separate unit and hire entirely new employees that had social work backgrounds. And listening to that back then led to, my 2010 most serious problems, saying the IRS needs to have a dual mission statement, and this is what they need to do. And you need to organize yourselves along this separate line with separate performance measures and separate, position descriptions. And you need to understand what your task is. And you can see how successful that's been since then. But I think that my personal opinion is that if the child tax credit survives and in some kind of advanced form, then there's going to have to be that cultural change. The IRS has no choice but to do that. And that's something we can all be really helpful with, describing mission, visions for that. The Family and Worker Benefit Unit, FABU. Melanie, do you want to weigh in here on your experience with Greater Boston Legal Services?
I hadn't really planned on it, but I guess just some of my reactions are that, research gets at a certain number of factors, but it can't drill down to all of them. And for the child tax credit and the stimulus payments in particular, the availability to the lowest income people, the availability to folks with no taxable income, brought into the picture a population that contains a subset who has, complete barriers to accessing these benefits. And even if they manage to have someone help them file a return, as you've said, Nina, there are countless reasons. They might get rejected automatically and need to paper file, but who knows that? Who knows that, you can contest anything. You may get notices from the IRS saying, we've reduced your refund amount. And basically, there's no quick fix for it, but there clearly are a set of people who absolutely need knowledgeable human help at those junctures, and we found also even to file. And the kinds of free legal assistance available are not homogeneous, and some legal assistance pays attention to plain language, pays attention to messaging, pays attention to the need for interpreters and bilingual staff. So there are different ways of doing things. My small project in the welfare law unit at Greater Boston Legal Services to try to bring more welfare recipients who are non-filers into access to these benefits. We put out the direct number to our unit. We eliminated all the barriers that Jim referred to that, often does exist, in legal services, and even for some of the services our program provides still exists. It's something we're really working on. And we got out the number to entities in the community that we know directly work with our clients, like family homeless shelters. So there are smarter and less smart ways of providing access to legal assistance. And it's not all lawyers, our paralegals are skilled legal advocates themselves. So, you can't throw out the whole concept of legal not working so well if you don't drill down to, well, what is actually being provided and how is it being provided?
Emma's comment was that one thing that I think might be missing from this conversation, particularly on the outreach side, is how we bring in participatory action research model, as in asking people closest to the issues, the families themselves, what works best for them. We've already seen that in the field right now with CTC. Some of the problems we run into is because we make assumptions about policy and program without bringing in the real experts. Those are the people who have had to navigate these benefits for a long time. Would be good to make sure that we think about that framing too. I go back to a survey we did, and this is an old survey, but it was a survey from 2007 of taxpayers who had been audited by the IRS, and this goes to burdens on the agency side. And we asked them a whole series of questions about their experience with the audit, and we found from that survey that 25% of the taxpayers who had been audited, we knew they'd been audited, whether they knew it or not, did not know that the audit letter from the IRS was actually an audit letter commencing an audit. And that 75% of the people who had been audited did not know what the IRS was asking of them to produce with the audit, which goes to learning costs, compliance costs, all the things that Pam and Don talk about in administrative burden. But that has a real result, a real consequence. If a quarter of the people being audited don't understand that they are being audited, that's going to drive their behavior going forward. Are they going to engage? Do they know what it is? And I think work like that is really helpful just on the side of both what's the messaging that you have to give taxpayers in outreach and education, and also what are the systems that need to be, the procedures and practices that need to be reformed inside the IRS. The other thing I've been wrestling with is the difference between outreach and education, that the IRS does a lot with outreach, shooting out posters or emails or RSS feeds, but we're really, you know, I've been really trying to focus on education, and that goes to the self-help aspect. How can people, even if they're not going to help themselves, how can we get them educated to know that they need help, that there is help there, or they can get a different result if they take certain steps or seek help to take certain steps. And I say that knowing, particularly in the population Melanie was describing, how hard it is to take that step, given everything else that's going on in your lives. Does anybody want to comment on Emma's, you know, comment or bring up other things?
I was actually just going to suggest, there's someone in the audience, Sarah Halper-Meakin, who's on the faculty at UW-Madison in the School of Policy there and the School of Human Development. And she's done a lot of work actually interviewing people on the ground, a lot of social welfare participants, including around EITC recipients, actually. So there is some really nice, I think, incredibly well done qualitative work that is essentially what Emma's talking about, the sort of a version of the participatory research. But I agree with her. I think like needs to be a lot of discussions with the people actually trying to access these systems to better understand what the problems are, and as well as possible solutions.
Well,
I'll just add and say as a point really well taken, and that I didn't emphasize this at all, but we did kind of interview staff and clients and prototype those materials, so they weren't just kind of designed on somebody's computer. But I didn't say that, so that's a point well taken. And I would say in our broader research, not just this area, something we're really thinking about.
Well, I want to open this up now for folks that are on the line to ask questions, give comments, thoughts, etc. Okay. If no one has, is there a Dylan, do you want to say this out loud?
Yeah, I was just curious. You know, I've heard a little bit about challenges that folks are having with the ID.me verification, and just curious if folks have any ideas on specifically how this intersects with the CTC, and any sort of ideas or work that's happening currently to think about ways to both sort of ease that burden, but also sort of address obviously the concern of why it exists is to, you know, prevent folks from using other people's IDs to access the CTC. I don't know if, you know, the conversation of possibly Social Security administering the CTC in the future, I don't know if that is one, you know, avenue that could potentially address that. Just sort of curious, just broadly ideas on this.
You know, I know from working with Code for America that when they introduced ID.me for their VITA app, Get Your Refund, that they really found that people had a difficult time navigating it, and they found that they had to basically assign volunteers to help people navigate the ID.me aspect, just being able to upload the photos, etc. And so it doesn't surprise me that people are continuing to have that problem. And the app itself is problematic, you know, in recognizing whether the documentation, the documents that you're uploading are current pictures enough of you versus your current snapshot. And there's supposed to be, you know, alternatives to being able to verify yourself. This authentication issue for the IRS is huge. It is, you know, guarding a database that is incredibly valuable and is subject to so many hacking attempts by the minute, every day of the year, every hour of every day, that it's set a very high level of authentication to be able to access anything. And that includes, you know, filing getting into an account, being able to do your non-filing update. And I am not an expert on that, and I've really tried to talk to experts about other ways to minimize that that burden. And I don't think we're there yet. And I think it may be that the balance is, that you put more people on the in-person authentication on the phones, to really help people through it, et cetera. But they're not, that goes back to resources. And Gabriel, you may want to talk about this because you're with Code for America.
Yeah, I mean, what you're saying is correct. It was definitely a barrier when we were trying to do it. So I was posting in the chat about this. But there's not an obvious other solution. I mean, there's, ID.me is arguably the right level of authentication for an online solution for the sensitivity of data. Doesn't mean it can't be improved as a product necessarily, but it does mean it's not like someone just put the wrong authentication level in. It's just we need to, the people do need to be this confident. So I think, some combination of having ways to do in-person authentication, phone-based authentication, these are the kind of solutions we need, but there's not there's just some other product that will solve the problems necessarily.
Right. It's really challenging. Any other thoughts or comments, questions? Do our panelists want to do some closing comments or thoughts? Give everybody a chance. Jim, you want to have some closing thoughts?
Sure. I want to emphasize about the legal services providers point. I couldn't agree more with some of the things that Melanie is saying, that context matters, that how legal service providers do outreach, how they communicate with clients matters enormously. And that's one of the things we're trying to research as we go along. I think the other point is that the structural changes in that an administrative agency can make can greatly affect the context of how, what kind of knowledge research produces, what kind of knowledge people, obviously folks who are trying to use different benefits or burden reduction schemes will encounter. And there's just a tremendous amount that right now the government appears to require that people do on their own that they really shouldn't. The government has the information that it needs to do a bunch of automatic enrollments. We see analogous situations with criminal justice record clearing, which is something that we research. We're researching pretty heavily at the Access to Justice Lab. We're trying to figure out whether it actually does people good. If you assume that it does do people good, it's a little hard to figure out why people should have to apply for it. The government has all the information. So if you assume, once you get to the part, which is what we're investigating, that it helps, it's kind of hard to figure out why you would need, person by person applications for that. And so I think this is, Pamela, you brought this up already, that there may be a lot of eligibility information that the IRS holds already. If you're already in a benefits program, why are you requiring people to apply for another one if they're pretty much default eligible in one sense or something like that? So essentially a lot of stuff that can be done internally that would obviate the need for some of the kind of administrative burdens that we're talking about. And I think we're all recognizing that's part of the picture.
Yeah, one of the things that Gabriel and I have really been after the IRS about is, just simply on the childless worker side, it's a small benefit. So maybe people aren't going to apply for it because it's just not worth it to get, but now it's been beefed up. The IRS has the W-2 information. It could automatically, after the filing season, go through when all of the W-2s have come in and most of the 1099 interest and everything, and go through and just say, oh, you didn't claim it. And you're here in our system, even if you just send a postcard saying, call us, confirm, and we'll send you a check. If you don't, going to Emily's loss language, you will lose out on a benefit maybe up to this much. And it could even be personalized because we have the information. And that's just a machine doing it. I mean, you need to do the programming, but you have to have the will to do it. And it's just a machine once it's programmed.
Yeah, one thing we've encountered in different policy areas, including, for example, discussions of loan forgiveness programs, is real concerns about privacy protections that limit data sharing across federal agencies. So across places like IRS, Social Security, and other agencies. And I think, some of this comes from folks in Congress who are very concerned about people's privacies, and that, there's a good reason for that. But it does feel like that's creating some real constraints on our ability to shift those burdens away from individuals and make processes more frictionless in ways that would really benefit people.
I think partly one of the things that we talk about, it is really about making explicit choices about costs and benefits, and really being explicit, for example, about the costs in terms of take up for a range of different benefits, both CTC and EITC, for example, when you have these impediments in terms of the ability to share information across agencies, and the consequence in terms of not being able to do a lot of automatic eligibility, for example, because of that inability, because we're concerned, for example, about privacy. I think we just need to have much more, we say this a lot, if you're talking about fraud, for example, we just need to be a lot more explicit and acknowledging the costs about this lack of take up, for example. And we don't do that. We require agencies to report fraud and abuse, or, overpayments and underpayments. But we don't require agencies typically to tell us, well, there are, 20% of your eligible population isn't getting the benefit. If we don't explicitly acknowledge that, then I think that plays out when we start thinking about how to, it plays out in negative ways, I think.
The other thing about data sharing is, and this sort of goes back to the FAFSA and also the, Affordable Care Act. The Internal Revenue Code contains a taxpayer consent provision. If the taxpayer consents to have that information shared. So on the FAFSA, if you're given a choice, like, would you like to download this information from the IRS? Like, who's going to say, no, I want to type in my entire tax return on the FAFSA? They're going to say, yes, please. And that's consent. And that lets the agency download it into the FAFSA, and yet you have to have the culture of thinking creatively in that way, and thinking about reducing burden, not just from your own agency perspective, but overall. You have to take a whole government approach. And I say this as someone who is really a protector, an advocate for protecting IRS data. So I'm, but Emily, do you want the final word?
Sure. So I do just want to reiterate what I said before about how I think, we need to be thinking about design and interventions considering administrative burden at all the levels, kind of policy implementation, and then nudging people in the world as it is, in the absence of the world as it should be. And then I'd want to make a quick pick up on what Pamela said earlier about culture. How do we create the culture? I think there's this tension between the nudging can be like a gateway to people seeing that these systems are not sensible. And if you need so much nudging to get through it, maybe there's a bigger picture to be thinking about. So in some ways, I think that's the promise. And some of the programs that we worked with said, like, wow, you helped me redesign this letter, and now I look at everything differently. But then I think the potential pitfall is that people say, well, nudging is enough and we don't need to fix the bigger problem. So I think that's the tension here, is that, I do want to celebrate that we can help people navigate the world as it is without letting that get in the way of trying to solve problems at a higher level.
Well, this has been a really great program, and I want to thank everyone who's on the call, but especially our session panelists for sharing their knowledge and their expertise. I've learned a lot. On the culture issue, we have a panel on changing culture coming up on Monday, November 8th. And I think that will be really interesting to talk about how you change IRS organizational culture. Next week, we have our panel on how we would change some of the policy rules, the eligibility rules that and some of that focus will be on changing the eligibility rules so that you won't have to apply again for the EITC or CTC if you're receiving benefits, SNAP for that child. Can we minimize burden in that way? Or expanding the definition of a qualifying child so that it takes into account the changing nature of the American family, like we learned about in the previous session. So stay tuned. I look forward to seeing you all next week. And thank you, everyone, so much. Yay to you all.